Welcome to the Road to Accountable AI. I'm Kevin Werbach, professor of legal studies and business ethics at the Wharton School of the University of Pennsylvania. For decades, I've studied emerging technologies from broadband to blockchain. Today, artificial intelligence promises to transform our world. But AI won't reach its potential without accountability, mechanisms to ensure it's deployed in responsible, safe, and trustworthy ways. On this podcast, I speak with the experts leading the charge for accountable AI. Dragos Tudorache is a member of the European Parliament, the former Interior Minister of Romania, and one of the most important policymakers in the world on AI. He's the co-rapporteur of the European AI Act, the recently adopted first comprehensive set of AI rules in the world. In our conversation, we talked about how regulating AI is not just about, or maybe primarily about, preventing things from happening. It's about enabling the technology to develop successfully. If you are at all involved in this area of AI, you need to understand what is coming with the European AI Act. So I hope you will enjoy my conversation with Dragos Tudorache. Welcome, and thank you for joining me on the Road to Accountable AI podcast.
Well, thank you very much for having me.
My pleasure. The AI sector is developing incredibly rapidly. Why is this the right time to adopt a comprehensive AI regulation?
Well, as you said it yourself, AI is advancing very rapidly, and I remain convinced that this is a technology that is going to drive the future with enormous possibilities, enormous benefits, enormous potential, but at the same time, with some risks that by now we have already started seeing materializing. And I'm not only talking about the big threats to humanity and stuff that we've seen on the television, but mostly day-to-day risks that basically involve you and me. And that was the basic thinking when at the European Union level we started saying, okay, so if these risks are real, and at the same time if this potential is real, can we just remain as we are, as we have been for quite some time in the digital sector, with absolutely no rules, with the companies governing themselves, deciding what is right and what is wrong? Or do we want to actually put some guardrails in place to signpost in a way the evolution of this technology? And the answer to this question was, we have to take on the responsibility of creating those standards ourselves, of saying and trying to develop those standards, to develop those guardrails in a way that brings trust. Ultimately, it's all about trust in the technology and the way it interacts with our rights and with the interests of society.
In Europe, though, it's not the case that there's no regulation of digital activity. You have GDPR, you have the Digital Services Act, Digital Markets Act, various other regulations. So what exactly is the gap that the AI Act is designed to address?
Well, it is designed to address exactly the applications of AI, which were not necessarily covered on many of them, not at all covered by the GDPR. GDPR was only focusing on the use of personal data, on privacy, and what that means for the digital realm, and also all the other legislation that basically was adopted in this mandate: the Digital Markets Act, the Digital Services Act, the Data Act. They all are part of the same vision back in 2019, when basically this European Commission with this European Parliament and Council set out for these 5 years to actually bring all of these tools in place, recognizing that this was time, from our point of view, to bring in some rules in the digital market. And they cover different aspects. The Markets Act covers the markets, the antitrust issues, and the accumulation of market dominance with some players. The Data Services Act is basically the responsibility of platform for the content that they host. Whereas the AI Act actually looks at the AI itself, but it does not regulate the technology of artificial intelligence. It looks at the uses of AI and then tries to identify what are those uses, those applications that actually brings risks and how to mitigate those risks. And as I said earlier, it puts clear rules in place only for those that actually bring those risks. And then the rest of the AI, and it's important to note that the rest of the AI out there, which is estimated to be, in fact, somewhere between 80 to 90%, is going to remain unregulated even after the AI Act comes into force.
Isn't there a danger, though, given how flexible the technology is, that leaving so much out of regulation then creates an opportunity for services to evolve or be used in ways that still raise some of those risks?
Well, it's a very valid question. Is this regulation, and it's a question that many ask, is this regulation actually future-proof? Is it able to basically remain relevant, to remain adapt to the evolution of technology, to whatever, ChatGPT 6, 7, or to any other application of AI? The answer is, well, of course, the reality will tell whether we've able to make it adapt or not. But we have addressed that in two ways. First of all, we've tried to identify those, or to express the obligations in a way that are technology neutral. So when we formulated the rules around transparency, we used wording that would ensure that that obligation will sound and be just as relevant 5 years or 10 years from now, no matter how sophisticated or changed the technology will be. At the same time, we also left open the areas that are identified right now as being, for example, high risk, understanding that the market will evolve, technology will evolve. There will be new areas that might prove in the future, 1, 2, 3, 5 years from now, to actually be raising risks. And therefore, the regulation can be easily adapted. We have a tool in the EU toolbox, which is called comitology, which allows in something between 3 to 6 months to adapt a piece of legislation as long as the mandate for adaptation exists in the text of the law. And we have deliberately included these mandates for adaptation in the text. So all of those parts where we thought technology will continue to grow, will continue to evolve, and therefore those parts will need to be constantly in sync with the reality of that evolution.
It's a balancing act, though, right? You want something to be clear and defined, but also flexible. And as you talked about, this legislation was a particular political compromise, a different set of interests. So, what gives you optimism going forward that this is the right approach as the industry and the technology evolves?
Well, as you said yourself, it was a very delicate balancing act, and it's a result of literally hundreds and hundreds, if not more, of hours of work, both separately, each of us as co-legislators in our corners, and then afterwards through, again, hours and hours of negotiations. And while that may sound very complex and heavy, it actually does bring something good out of those hours of negotiations, because it allows it to distill what is most important to put in a piece of legislation. And I think that we managed to find that balance. On one hand, what we try to do is to find the balance between the benefits and the risks. Because as I said at the beginning, we don't want to put this label of risk on AI. AI, again, is a fantastic technology that I'm convinced will help us as humanity to solve cancer. It will help us to go to Mars. It will help us to do amazing things in almost every walk of life, every walk of human activity. So on one hand, we wanted to make sure that we also put the right enablers in place through this legislation and create the space for innovation to continue to grow and actually to invite for even further innovation in the market. But at the same time, to give that confidence that we are addressing properly those risks. And we're not ignoring them. We're not sending the signal to society that, okay, well, we're leaving you out there to face this technology alone without any safeguards. And again, one balancing act was to find that equilibrium between the protection and the innovation. And I think, again, we've managed to solve that equation. And at the same time, that balance that you refer to, which is how much do we put in the text right now? And again, how do we make sure that we are looking sufficiently ahead as to how the technology will evolve to make sure that we remain relevant with this piece of text. And we've also introduced something that is not known or common in the EU rulebook, which is what I like to call flexible enforcement, and also flexible and very inclusive governance, which means that the decision makers of the future, those that will be called upon based on the mandates that we have introduced right now in the text, as I said earlier, that will be called upon to adapt the legislation, they will not be doing it in absence of being constantly in sync with the reality, because we've introduced an advisory group, a scientific board that will be constantly feeding what happens in the industry to the decision makers in the future AI office of the European Commission, so that those adaptations will actually be mirroring the reality. as accurately as possible what is happening at a given time in the technology itself.
So one area in particular that relates to this issue of future proofing is generative AI. The original text of the act didn't really talk about generative AI, and then ChatGPT came along, and obviously it was important. And so there was something of a scramble to put those provisions in about general purpose AI. Is it a concern that there was not enough consideration about how to address these issues around foundation models and so forth?
Well, it may sound arrogant if I say it, but we haven't really scrambled doing that. If one, for historical reasons, if not anything else, if one would want to look at my original amendments from back in 2021, I had introduced there the concept of AI authors. This is how back then in my mind I was thinking of that. Of course, ChatGPT was not yet on the market, but through the work that we had done, and this is again something that I don't know how much is known, but we had really taken our time to prepare for the moment when we started this legislation. We had a special committee on artificial intelligence in Parliament, which I had the honor of chairing, where for almost 2 years we have looked into every aspect of AI. We have listened to all possible stakeholders from every walk of life, from any perspective, looking at the same issue. That allowed us to educate ourselves, to grow our understanding of the technology and what it was that we were embarking to regulate. And during those discussions, I heard for the first time, coming from some of the recognized thinkers, let's say, on AI, I heard the concept of general purpose AI, as it was called back then. And this technology that was bubbling out of the surface, which then later popped up to be the large language models, the LLMs of today. And I was hearing these thinkers, these authors saying, listen, there is something to this technology that needs to be well understood and also cannot leave regulators indifferent, even if them in themselves don't have a purpose that you can easily pigeonhole as the rest of the regulation does with other applications. So we've realized rather quickly that we need to think of a different kind of a regime, of a different approach to this type of AI, let's say, this species of AI, the Gen AI. And already prior to ChatGPT coming to the market, in the team of the Parliament, we were already discussing how to actually formulate this regime of rights and obligations, and what we will actually be putting into that regime. And then what ChatGPT did, and then the rest of the debate rolling very quickly on generative AI, in a way, it gave us the confidence that we were on the right track. And that we were not just ourselves being paranoid about it, that actually there was something with this technology that required some rulemaking of its own. And that's what we've done. This is what then came to be the special chapter on what we now call foundation models in the area.
And at the very end of that process, though, there was significant pushback from France and Germany in particular, that segment was overly regulatory. So what did it take to eventually resolve that dispute and get enough consensus for the legislation?
There was indeed pushback, not only from France and Germany, but there was also a considerable pushback from the industry itself, which basically argued at the beginning in two directions. One direction saying we don't need regulations at all for us, because what do you know? We are just language models. We are processing text at the end of the day. So what can be harmful in that? Then they abandoned that line of argument because the public debate, and there were already evidences of actually what it could do with these models. And then there was another line of argument from them initially that was saying, listen, the responsibility is not with us. It's further down the line in the value chain with those that would be taking our models and doing all sorts of things with them. So we have no responsibility. The responsibility should be with those that are taking our models and using them for a given harmful purpose. But as we were discussing and as we were finding counter arguments to those, then the discussion pretty much focused, and this is where also as you mentioned, France and Germany came in the debate, in terms of finding a more balanced way, speaking of balance, a more balanced way to actually deal with the obligations towards these models, understanding how fluid the technology still was, how nascent, and how much we still didn't know, not in terms of what we wanted these models to do or to prove, but how to actually measure that. how to test, how to evaluate, how to actually make sure that you can enforce those obligations. So this is where we accepted the argument that came from France and Germany, for example, for a more flexible enforcement, at least at the beginning. Those standards and benchmarks would actually start developing in the market. And therefore, we've landed with this solution that is now the Act, with codes of practices that would basically establish how the obligations are set in stone in the regulation, but how you actually measure and enforce those obligations is the result, or will be the result of a code of practice that will be developed and co-developed, in fact, between the developers and the regulator. And that will plug the gap until standards will be available, and then standards will be taking over and will be representing the measuring stick with which the developers will be judged by the regulator. So I think that, again, with this construction, we've managed to find the balance between those that fear that we may be going too fast, too far, and those, including myself, that wanted to make sure that at least some responsibility is clearly fixed in the regulation.
There's a general issue, though, related to what you just talked about in terms of the degree of specificity, not just in the foundation model section, but there are many requirements about conformity assessments and explainability and so on and so forth that companies are going to have to meet where the details are not yet in place. So, how do companies get started on compliance? I understand there's a period until the effective dates, but how do they know enough about what exactly they're going to be required to do to be able to comply when some of these details are not yet in place?
Yeah. Clearly, there's a risk whenever you're doing pioneering legislation such as this one, this risk exists. But we have tried to learn a very, I think, valuable lesson from GDPR, which came to the market with no technical standards, which made it very difficult for companies to figure out, to understand what it was they were expected to do. And in fact, without going and calling a lawyer, it was almost impossible, particularly if you were a small startup, to make the determination yourself. So this is why there is a mandate for technical standards. So technical standards will have to be developed by the time the regulation will come into effect. And that will help in understanding actually what it is, what explainability is, how data accuracy needs to be understood, so on and so forth. So all of those things that right now may sound a bit too generic for some of the readers will be clarified via technical standards. And very importantly, these standards will not come from heaven. They will not be bestowed upon the world by the European Commission. We deliberately change the logic of that by giving this mandate to standard setting bodies, those bodies where in fact the industry itself is present, so that they can, with their knowledge, with their expertise, they can actually develop and work on those standards themselves, so that at the end of this process, again, 2 years from now, when the law will come into effect, there will be a set of written text that will help an engineer understand what it is that they have to do. Second, in many parts of the text, if one takes a look, you'll see there is again a mandate for guidelines that is supposed to come either at national level from the national regulators or at European level from the European Commission and the future AI office, that are also meant to translate some parts of the text or of the requirements which we also thought would be too legalistic or too generic, and which required that sort of translation or further explanation. And those are also mandated to be done before the entry into force of the regulation. So all this to say that basically by the time that companies will have to comply, those that they'll have to, and including to help them self-assess, which is the basis of this regulation, self-assessment, they will have the tools to do that self-assessment, to know where they find themselves on the pyramid of risk, whether they have to ignore the text altogether because they're not concerned at all, or if they are concerned, what they need to do.
What's your perspective right now on the Biden administration's approach to AI policy in the U.S.?
Well, I think the Biden administration did what they could do in the absence of action from the Hill. I think for a while, so first and foremost, the Biden administration renewed the dialogue with the European Union and created the Trade and Technology Council framework, which allowed the two executives, the two administrations, EU and US, to start discussing very concretely, among other things, AI, and not only in terms of very generic political narratives and alignment of values, also very important, but also in terms of putting together the NIST on the US side with the European Commission, and then having experts talk to themselves, discuss standards, discuss how you measure different things, how do you measure bias in an algorithm, so on and so on. So very concrete things. But beyond that, again, the administration looked at the landscape of norms and said, listen, if we, from a political point of view, if we agree that this technology, apart from the huge benefits, comes with certain risks, what do we do about them? And again, if Congress does not act legislatively, what else could we do? And I think the first response was the Bill of Rights, which was the first statement of intent, I think, politically by the administration as to what they believed needed to be done or signaled towards the industry working with these technologies, and then the executive order, which I see it as a measure that again is meant to start determining certain behavior, starting with the federal administration in terms of how to regard AI, to give the impetus to start analyzing sector by sector what could be not only the benefits, but also to see the potential risks and start thinking and addressing these risks, each of them in their sector, which is, from my point of view, a good approach as well. We had also considered at EU level whether to go horizontally, as we eventually did, or to go sector by sector. We chose horizontal for certain reasons, but it doesn't mean that sectoral approach is the wrong one. So, in fact, if you unpack the logic of the executive order of last autumn, that logic is not very different from what we ended up doing with the AI Act, only that the Act is a law, whereas the executive order is not. But again, I think the administration did the most that it could with the tools that it had.
How do you see the global coordination going forward? It's, of course, not just the US, countries like UK and China and others are very active in this area. How much does there need to be consensus globally on these regulatory areas?
Well, from my point of view, it's a must. It's not nice to have. It's not a luxury. It is a priority because AI is the same for everyone. And AI will be driving the future. So one way or another, there has to be a global conversation about AI, and ideally there has to be an alignment on how you deal with the technology. In a way, if there was one huge benefit with ChatGPT and the LLMs, was that it triggered that conversation. There were attempts prior to that to actually stimulate that level of interest in all jurisdictions out there, in various fora, in various formats. There was some lip service paid to it, but you couldn't really feel the sense of urgency or the sense of purpose in those conversations until last year, when all of a sudden the world leadership woke up to the reality of AI, helped also by some of the public debate and some of the key figures in the public debate, whether in the industry or in the academia, saying, listen, folks, start looking at this seriously because there are some even existential threats linked to this technology. So that actually stimulated the attention. And then we saw the whole plethora of summits and also some bilateral or multilateral fora discussions on AI, which is a good thing. Now, what we need to do is to start landing all of these different conversations and formats and start, it's not going to be simple, but start trying to converge towards ideally a single framework in which this conversation takes place. I think that not only the democracies around the world, certainly the democracies around the world need to get themselves aligned because they share values, and that helps. But also going past the democracies of the world, even with those that understand technology in a different way and the interaction between state and technology in a different way, China and others, I think even with those, that conversation needs to take place. Now, there are, again, various formats in which these discussions are taking place: G7, OECD, GPI, G20, so on and so forth, bilateral frameworks such as the TTC for the EU and the US. There are other TTCs and other bilateral formats going on with India, with Japan. But again, I think there needs to be, slowly but steadily and surely, there needs to be a convergence of all of these conversations so that there would be ideally at some point one framework where we discuss it. And then the second thing is that we now start seeing different embryos of governance starting to emerge in different jurisdictions. We have the AI Act with the AI Office, which is now taking shape. We have a safety institute in the UK following the Bletchley Park Summit. We have a safety institute based on the executive order in the US. I had conversations with the Japanese government recently. There is now a safety office in Japan with the leadership already elected. I understand there will be soon one in Canada. And I guess that we will be seeing this trend continuing in many other corners of the world. I have been speaking quite a lot with parliaments and governments in Latin America. There is a lot of energy there as well. There are actually bills on AI being worked on right now in the Argentinian and in Brazilian government parliaments, in Chile, in Peru, in Uruguay. So as these governances in every jurisdictions are starting to emerge, I think there is again, it's not a luxury, it's a must that they have to start networking, because they will all be developing different methodologies, different benchmarks on how they evaluate, on how they measure ultimately the same models, because the same models are popping up in all of these jurisdictions. And it would be totally irrational from my point of view to actually develop these methodologies in separation from each other. On the contrary, I think there'll be enormous benefits if this networking is done as diligently and efficiently as possible, so that, again, commonalities are being sought out of that convergence.
Yeah, I mean, it sounds like what you're saying is that there is a great deal of harmony in terms of general viewpoint around the world, which is consistent with what I see.
But harmony is not too strong of a word.
Maybe that's too strong a word, but yes, at least a similar. Well, I guess what I'm thinking of is at least from my perspective, with regard to data protection, there really has been a conceptual difference between the European human rights based approach and the U.S. vision that sees this really as more commercial, transactional, and so forth. Whereas here, it seems like everyone sees the same broad sets of issues, but in implementation. Okay, so that's that's optimistic.
Yeah. We're in a way in a different logic than we were with the GDPR, where clearly I think the concept of privacy was understood differently in different jurisdictions, whereas now I think most jurisdictions are looking at AI in the same way.
So let's say I'm an executive at a company that is operating in Europe or has customers in Europe, would be subject to the AI Act. What should I be doing right now?
Well, I'll be, first of all, seriously looking into the AI Act, try to understand it, and also look at my business and see, am I concerned by it or not? Because I stress this point again, AI Act is not for all of AI. There's 80%, maybe even more, of AI out there that will remain unregulated. Because if your AI deals with any optimization of an industrial process, or optimizing transport or energy flows, or whatever it is that they do that does not intersect with my rights as an individual or with broader values in society, then your AI is not concerned by the AI Act, and therefore you should not worry. You should continue to do the business that you do. But if you do find yourself in one of those business areas where your AI is interacting with my rights, whether you're doing AI in recruitment or in education or in health or in banking or insurance or any of the issues of the contexts that are listed in the AI Act, then you have to ask yourselves the question, okay, so then my AI might come under the Act, so that I need to start preparing for that. I need to start documenting how my AI works, the data sets that I use to train the algorithm. So prepare already now in advance of 2026, when the rules will come into force, to make sure that by the time I am sufficiently prepared.
What comes next? For you, I assume you could use a lot of sleep, and also there will be elections in Europe and so forth. But substantively, what is still on the agenda or next on the agenda in this area?
Well, now that we've done all of the legislation, and that's important to know, all of the legislation, it's not only AI Act, that was put on the table, this mandate is now done. So now, evidently, we're looking into the implementation of this legislation, and I would venture a guess for the next political cycle at the European Union level, the next 5 years, that we won't be seeing a lot from my point of view, we shouldn't be seeing any new legislation in this area for the next 5 years. But even if we will see, it will be limited in scope. So I think in a way, this is it in terms of the package. And now for the next mandate, it will all be about landing all this, landing the plane, or implementing, preparing. So if you ask what the next challenges will be for the coming 5 years, there will be a challenge for the regulators, which will now have to shape up, get the expertise they need, bring in the tools they need to do their jobs, prepare for that moment when they will be acting not only as enforcers, because as I was saying earlier, there is a balance in this text that is not only about enforcing the law, but also about facilitating, about guiding, about working together with the industry to achieve objectives that are in fact shared. So there's a lot of shaping up to be done at the level of the future regulators, and they are starting to do that. I had 2 days ago a discussion with the national regulators. They are starting to get in shape. The area office will be shaping up soon as well. So that is, let's say, objective number one. Objective number two for us as policymakers, very importantly, we will have to start explaining. Because we've moved and we've focused and we spent a lot of energy during these years negotiating, adopting these texts. Now they have to be explained. We'll have to do a lot of pedagogy, not only with the companies that are going to be subject to the law, but we're going to have to start explaining AI to our citizens. Because if society does not embrace this transformation, if they don't understand what is happening, if they don't actually gain that trust in that interaction with technology, I think there'll be no uptake, and everyone then loses, everyone suffers. And also AI is going to have a transformational effect for a lot of things that are having to do with people's everyday lives. From the way education is going to be done for kids to the way our jobs are going to look like 2, 3, 4, 5 years from now. So all that needs to be unpacked for the general public so that, again, society understands what's going on. We'll have to, again, look very seriously at our education methods, who are going to be revolutionized by LLMs and whatever comes next after LLMs. We'll have to prepare our labor force and reskill and upgrade our labor force so that they start absorbing the reality of AI, the tools that will come and, yes, replace some parts of their jobs, not their jobs entirely. Some jobs actually will be maybe even rendered obsolete. We have to prepare for that. There will be other new jobs being created that we cannot even think of right now. All that transformation of the labor market also needs to be understood, debated, unpacked, so that no one feels left behind in this transformation. Because if that happens, again, then the debate about AI becomes ideological, becomes partisan. And there is the last thing we need for a technology that is, again, so impactful for our future. And if we let it, again, fall into the trap of partisanship and ideological debates and fear and scaremongering, well, then, again, well, that whole benefit and potential is going to be lost.
Quite a lot of work ahead, but quite a lot of opportunity ahead. And I share your enthusiasm.
Absolutely.
Absolutely. Dragos, thank you so much for your time today.
You're very welcome.
This has been The Road to Accountable AI. If you like what you're hearing, please give us a good review and check out my Substack for more insights on AI accountability. Thank you for listening.